We had a kind of a lull midweek, didn't we?
Ladies and gentlemen, I'm advised that we do have verdicts on each of these matters. And again, I will ask you to please refrain from any outward emotions until the jury has done their duty and been excused. All right, let's bring the jury in.
Yes, sir.
All rough it, Mike.
Okay.
Juror number 80, Ms. Foreperson, I understand you've reached a verdict or decision as to each of the sentences in the 4 homicides, or the 8 homicides actually, but merging the 4. Yeah. Okay, and were those unanimous verdicts?
Yes.
And did you memorialize those verdicts on the 4 verdict forms provided to you?
Yep.
Okay, what I'm going to ask you to do is, one, stand. Mr. Reinking, if you'll stand as well. When you read the verdict, read the caption, State of Tennessee, just one time, but you'll have to read as to each of the 4 victims.
Okay.
Your verdict.
You ready?
I'm ready.
All right. In the criminal court for Davidson County, Tennessee, Division 6, State of Tennessee versus Travis J. Reinking, Case number 2019-A-55. Punishment of imprisonment for life without possibility of parole or imprisonment for life. Counts 1 and 13, Joe Rene Perez Jr. We, the jury, unanimously find the state has proven the following listed statutory aggravating circumstances beyond a reasonable doubt. Defendant knowingly created a risk of death of 2 or more persons other than the victims murdered during the acts of murder. Defendant committed mass murder, which is defined as the murder of 3 or more persons, rather committed during a single criminal episode or at different times within a 48-month period. Therefore, we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole. Punishment of imprisonment for life without possibility of parole or imprisonment for life. Counts 2 and 14, Taurean Sanderlin. We, the jury, unanimously find the state has proven the following listed statutory aggravating circumstances beyond a reasonable doubt. Defendant knowingly created a great risk of death of 2 or more persons other than the victims murdered during the acts of murder. And defendant committed mass murder, which is defined as the murder of 3 or more persons, whether committing during a single criminal episode or at different times within 48-month period. Therefore, we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole. Punishment for imprisonment for life without possibility of parole or imprisonment for life. Counts 3 and 15, Akilah Dasilva. We, the jury, unanimously find the state has proven the following listed statutory aggravating circumstances beyond a reasonable doubt. The defendant knowingly created a great risk of death of 2 or more persons other than the victims murdered during the acts of murder. The defendant committed mass murder, which is defined as the murder of 3 or more persons, rather committed during a single criminal episode or at different times within a 48-month period. Therefore, we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole. Punishment of imprisonment for life without possibility of parole or imprisonment for life. Counts 4 and 16, DeEbony Groves. We, the jury, unanimously find the state has proven the following listed statutory aggravated circumstances beyond a reasonable doubt. The defendant knowingly created a great risk of 2 or more persons other than the victims murdered during the acts of murder. The defendant committed mass murder, which is defined as the murder of 3 or more persons, whether committed during a single criminal episode or at different times within a 48-month period. Therefore, we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole.
Thank you, Chief. And Madam Board Person, did each of the jurors, all 12 jurors, sign
Yes.
each of the 4 verdict forms?
Yes.
Is there anything else from the state?
No, Your Honor.
Anything from the council? All right, all may be seated. All right, members of the jury, that concludes your service on the trial of this particular case. I don't guess you want to come back next week, do you? You're actually good to go for 2 years. You can't be brought in more than once every 2 years. So I want to come back and personally thank you and talk to you for a little bit in a few minutes. I've got some things I got to do here in the courtroom. But when I'm finished, I definitely want to come back and thank you for your service. I know it's been an intense, emotional week for all of you, and we can talk some more when I get back there. If you'll just please hang with me, we'll get you back to your hotel room, let you get all your stuff, and I think all your loved ones and significant others are on call and anxiously awaiting the opportunity to come down and pick you up, and I'm sure that you're anxiously awaiting their arrival. But if you'll give me a little bit of time, I would like to speak to you. All right, so you can step on back. All right, Mr. Reinking, if you would please remain standing, sir. The State of Tennessee versus Travis J. Reinking, case number 2019-A-55, in counts 1 and 13 in the first-degree murder and first-degree premeditated murder and first-degree felony murder of Joe Rene Perez, Jr. The judgment of the jury, the verdict of the jury will become the judgment of the court. The other convictions we'll just postpone until sentencing hearing to determine consecutive and concurrent sentencing. And I mean, I'm bound by the other ones that they have imposed on all of these homicides, but we still have the issue of concurrent and consecutive sentencing. And of course, I do the sentencing on all the other ones, as both the length and of sentence as well as whether they're concurrent or consecutive, although some of them are mandatory consecutive. But in any event, point being is I'll deal with the rest of everything else at that sentencing hearing. Because of my situation, if we can maybe look at early May and see where I am in that process and adjust it accordingly if necessary. Okay?
Yes, sir, that's certainly fine with the state.
I mean, I know we're supposed to do it in 45 days. Is there any issue about?
No, sir.
All right.
May 5th.
Let's try May 5th. I might be in a position to come in and just deal with that one matter, but we'll see. All right? And just set aside, what day is that?
It's a Thursday.
Now, let's set aside a day separate and distinct.
May 6th.
Yeah, let's try May 6th. I wouldn't want it on a regular docket. I mean, it could take a while. And even if it doesn't, I suspect there's going to be a lot of people that will still want to be here. So we'll try May 6th at 9 o'clock.
Yes, sir.
And Your Honor, for the record, the state would ask that the court at this time, its 13th juror, officially accept the verdict of the jury in both the guilt, innocence, and the punishment phase.
Well, I'm bound to accept that on the ones that they have imposed, but if I impose judgment on the other three without the issue of concurrent or consecutive sentencing,
I think it's more of the accepting the jury's verdict.
I definitely
It's
accept
guilt,
it.
innocence,
Yes.
and approving that verdict.
Yes, the guilt or innocence, I accept all 16 findings of guilt. I will set counts 2 through 16, removing 13 from that for sentencing hearing on all issues. But the verdicts themselves, yes, the guilty verdicts themselves, I accept and make those judgments of the court.
Thank you, Your Honor.
All right, anything else? All right, court's in recess. I'll tell them. I told the attorneys.
Okay.
I'm only going to sign, because I don't want to, well, Jason.